Welcome to Term Talk, a video podcast from the Federal Judicial Center that discusses each term's Supreme Court decisions likely to impact the lower courts the most. I'm Hamid, a judicial education attorney at the Federal Judicial Center. In the next 15 minutes, we'll discuss the court's recent opinions about racial and political gerrymandering, redistricting, and briefly explore recent applications of Purcell versus Gonzalez, known as the Purcell Principle. Joining me today are Erwin Chemerinsky, Dean, and Jesse H. Chopra, Distinguished Professor of Law at the University of California, Berkeley School of Law, and Evan Lee, Emeritus Professor at the University of California Law, San Francisco. Thank you for joining us today.
Great to be with you.
Nice to be here.
Erwin, Alexander v. South Carolina State Conference of the NAACP addresses the difficulty of distinguishing between racial and political gerrymandering. Can you get us started?
The Supreme Court has said it violates equal protection if race is used as the predominant factor in drawing election districts. But the Supreme Court has also said that challenges to partisan gerrymandering are non-justiciable political questions. This then raises the issue that comes up often in districting. Was it on the basis of race or was it on the basis of politics? And the problem is that in certain areas, Black voters vote Democratic over 90% of the time. And that's ultimately what this case is about, how to figure out if it's race or if it's politics. It involves South Carolina. Like every state, South Carolina engaged in redistricting after the 2020 census. There had been some significant population shifts. And so when the South Carolina legislature met to do redistricting, it said it would follow the traditional factors, looking at contiguity, looking at covenant protection, being careful of equal protection. They also were clear they wanted to help preserve Republican seats and help Republicans in terms of winning seats for Congress. Well, they engaged in redistricting that involved a substantial shift of Black voters. 140,000 Black voters were moved from District 1 to District 6. 10 of the 11 districts, or precincts rather, with predominantly Black residents ceased to exist. And so the plaintiffs brought a suit saying that this was vote dilution with regard to Black voters, that it violated equal protection. There was a 3-judge federal district court, and it held a trial. And it found that race was a predominant factor with regard to the districting. They said that the legislature used a target of 17% for the Black population in District 1. The 3-judge court said that this had the effect of diluting the Black vote, and the district court enjoined the use of the map that had been drawn by the South Carolina legislature. The United States Supreme Court, in a 6-3 decision reversed, the Supreme Court said that the district court failed to give sufficient presumption of good faith to the legislature. The Supreme Court found that as a result, there was clear error by the 3-judge federal district court.
Evan, how did the court analyze the case?
Well, as Erwin has already indicated, a 6-3 majority found that there was clear error by the district court in finding a racial gerrymander here. The court acknowledged that clear error is a demanding evidentiary standard, but at the same time, it is not a quote unquote rubber stamp. And in particular, the district court failed to apply 2 important evidentiary rules that effectively create demanding burdens on plaintiffs in racial gerrymander cases. First, again, as Erwin alluded to a moment ago, the lower court should have applied a presumption of legislative good faith. The court here says that federal court findings of racial gerrymandering are disfavored because they impugn the honesty and integrity of the legislature. After all, legislators take the same oath to enforce the Constitution that federal judges do. And then second, the court said that because the plaintiffs provided no direct evidence of a predominant racial motive here by the legislature, in other words, no smoking gun evidence like leaked emails or something like that, it was incumbent upon the plaintiffs then to produce an alternative map, and their failure to produce that alternative map should have created an inference against them. In other words, the district court should have drawn an adverse inference against the plaintiffs for their failure to produce this alternative map. Now, an alternative map would have been a hypothetical map that would show that it was possible for the legislature to achieve the same partisan objectives, but without the same degree of racial skew or racial impact as the challenged map. As for arguments that the plaintiffs didn't know that they were going to have to produce such a map, because after all, the state never offered up a partisan gerrymandered defense prior to trial, the court was unmoved, and it said, well, you were on notice. The plaintiffs were on notice that they should have realized, because of the dynamics of the case, that at trial, the state would defend differently than it had in non-litigation situations. Then moving to the merits of the evidence, the majority did a deep dive into the methodologies employed by the plaintiffs for social science experts and found all four of those reports fatally flawed for various reasons. And therefore, the court determined that their testimony shouldn't have been accorded weight by the trier of fact.
Evan, Justice Thomas's concurrence went further. What did he offer?
Well, he went further and he didn't go as far. He didn't go as far as the majority with respect to the treatment of the four experts' testimony. He said he called the court out, frankly, for not properly applying clear error review. He said, you don't get into the weeds of social science methodology if you're applying clear error review. That's for the trier of fact. However, he did join the rest of the court's opinion, and of course he agreed that the court was correct on the ultimate judgment, but for a very different reason than the majority articulated. And that is Justice Thomas called for all gerrymander claims to be non-justiciable. At present, and under the majority's opinion, racial gerrymander claims are still justiciable. They're obviously very difficult to bring after this opinion, but they are still justiciable. Justice Thomas called for all gerrymander claims to be found non-justiciable. And he said there were multiple reasons for this, one of which was that the historical equity practice in federal courts doesn't extend to redrawing maps. And as for negative injunctions of the ex parte Young type, they're not effective in remedying this kind of discrimination. And furthermore, he found it very important. He said that state legislatures are currently in a lose-lose situation, as between trying to thread the needle on the Voting Rights Act, where they have to take race into account to satisfy their obligations under the Voting Rights Act, but at the same time, race can't be a predominant factor under equal protection. And so he said that legislatures should be released from that catch-22.
Erwin, in contrast, stood the dissent. How did they analyze the case?
It was a vehement dissent. The dissent objected to putting the presumption of good faith over the need for deference to the finding of a three-judge court. Part of that is, I think the dissent doesn't agree that there should be so much deference to the legislature. Some of it is the dissent saying, here you had a trial court conduct a trial, heard all of the evidence, valid credibility witnesses, and the Supreme Court gives no deference to the trial court in that way. The dissent is objecting to how the majority isn't following clearer analysis. The dissent also objects to the requirement of a particular kind of evidence, the alternative maps. And the dissent objects, saying that this is really going to make it impossible to bring challenges to racial gerrymandering because it'll always be possible for someone to say it was politics instead. The dissent said that's really abandoning precedent, even very recent precedent.
Before we get to the takeaways, I want to talk to you briefly about another case that appeared on the court's emergency docket this term. Can you explain the implication of Robinson v. Callais and what some may find a surprising dissent from Justices Sotomayor, Kagan, and Jackson?
This involves what's often been called the Purcell principle. The Purcell principle comes from a Supreme Court opinion in Purcell versus Gonzalez that says that courts shouldn't get involved in the election soon before the election. We saw this, for example, in 2020, where the Supreme Court said it was wrong for a federal district court in Wisconsin to extend the time for absentee ballots soon before the Wisconsin primary. Well, this involves litigation that's gone on for some time regarding districting in Louisiana. There's objections to the districting as violating the Voting Rights Act. The court ordered a new map to be drawn. And what happens here is the Supreme Court says it's too close to the election to draw the new map. Now, the irony of this case is that it's a map that would favor Black voters. And so one would think the liberal justices would be more inclined for what the district court's done. But instead, it's a 6-3 decision with the liberal justices in dissent and the liberal justices criticizing the application of the Purcell principle in this circumstance.
Erwin, so what are the takeaways from these two voting rate cases for the lower courts?
I think the takeaways are quite different. I think with regard to the South Carolina case, the takeaway has to be it is going to be very difficult to prove that it is racial gerrymandering when the legislature is able to say that it is based on party politics instead. It's a case that establishes a strong presumption in favor of the legislature. I think it's also a case that may change the meaning of clearer review beyond the voting context. Robinson versus Callais is different. I think what it shows is a majority that is very serious about the Purcell principle, but the uncertainty there is going to be how far before the election is enough to avoid the Purcell principle, or at what point is the Purcell principle triggered? And this is something the Supreme Court's never answered.
Evan, what takeaways would you offer?
On the same lines of Erwin's comments about Callais, I think there is going to be a great deal of uncertainty and variability in the application of it. Just how close is too close to an election? That seems to be a pretty slippery slope. Also, I think I would be tempted, if I didn't know better, to call this Purcell principle another form of abstention. The Supreme Court hasn't created any new forms of abstention in a while, but I wonder whether this is one. And if it is it based on the Constitution? Is it based on the inherent equitable discretion of the federal courts? We may have to see. As far as Alexander is concerned, I absolutely agree with Erwin. This is going to make bringing racial gerrymander challenges in federal court much, much more difficult. And I also wonder whether this case is going to have some kind of an effect down the line on the court's interpretation of Section 2 of the Voting Rights Act.
Well, thank you both for spending time with us today and discussing these critical and timely cases.
Thank you.